This is Michael Popok, Legal AF. Donald Trump has lost again in record time. His trial team for the civil fraud case in New York before Judge Engoron filed late an application with the New York First Department Appellate Division, which is the first level of appeal, an appellate court just above Judge Engoron, seeking a whole bunch of things to blow a hole and disrupt the trial. After the second week of trial had already started, but Donald Trump had fled to go back to Florida after watching 2 days. The lawyers today, while the trial was still going on, in which a key insider money man witness for the Trump organization, the longtime 40-year controller, Mr. McConney, was testifying. Chris Keiss, the lead lawyer, was not in the courtroom for the trial because they were busy putting the finishing touches on their emergency appeal to the First Department. So they filed the appeal, and what they wanted, they did not get. They wanted a stay of the entire trial. Listen, we're only on the second week of a trial that's going to go on for 3 to 5 months. We're on the probably 5th or 6th trial day on a case that's going to go 100 trial days. And so for them to say, well, we've already had 3 witnesses, let's stop the trial because we don't like where the judge is going, and we think the judge is making error, and we don't want to wait for an appeal at the end of his ruling. We want you to do something about it now, appellate court. That was a dead on arrival argument from the beginning. They also argued and they attacked the remedy that Judge Engoron fashioned when he granted the summary judgment last Tuesday. If you don't know, I'll tell you right here on this hot take that when the judge granted the motion for summary judgment, finding that the New York Attorney General, the Office of Attorney General, the OAG, had properly made out her case on the first count of her complaint for persistent fraud, demonstrating that Trump and the Trump organization have been conducting a fraudulent operation, and they've been victimizing the people of the state of New York for over 6 years, if not longer. The judge agreed and said, we don't even need a trial on it. It's so obvious from the undisputed factual record that persistent fraud has happened. And he said, in addition, I'm going to grant 2 of the 9 things that the OAG is looking for. I'm going to cancel the corporate licenses to operate, the certificates of incorporation or limited liability company for all of Trump's incorporated entities, no matter where they are, immediately, and have a receiver dissolve all of those companies and work on their assets. And I'm going to appoint that receiver or monitor over the case. That was the ruling. We would have thought that and my recommendation, if they were taking it, based on my trial experience, is they really should have had their appeal ready to go the minute the summary judgment order against them dropped. Like, you have it ready beforehand. You then look at what happened, you modify it over an hour or 2, and you get it on file. That shows that this is important to you, that you're going to suffer irreparable harm or injury. But they waited over almost 2 weeks in order to file their appeal. And when they finally got around to it, they asked the appellate court to stay the trial, to stop the companies from being dissolved at present, and to stop the appointment of a monitor. Also, they didn't want to respond to Judge Engoron's latest order, which just came out the other day, in which he further ordered that the Trump organization and all the entities reveal all of their companies, all of their corporations, including any new corporations that they might be thinking of transferring assets to avoid a future judgment against them for $500 million, and tell the monitor and the court about those assets. And they didn't want to do that either because, in the past, they had tried to set up a Delaware corporation to get out from under the New York law that's been triggered here and try to be a Delaware corporation. And they got caught red-handed about a year ago by the Attorney General's office, who brought it to the judge's attention. They're going to Delaware. And, the judge eventually issued an injunction and installed a monitor. What did the appellate court do today? There was an emergency hearing down at where the First Department on Madison Avenue, I'm a member of the First Department, hears cases. And they brought Letitia James and they brought the lawyers for Donald Trump in. It was a 1-judge hearing. Why? Because when you file for an emergency application, 1 judge of the panel of the entire First Department gets assigned for that emergency application and makes the ruling on the spot, subject to it being vacated by the full panel when it's established. Eventually, but not now, there will be 5 justices assigned to this appeal. They are referred to in the business as the merits panel. They go to the merits of the case. The emergency application goes to an emergency judge or panel. In this case, it was assigned to Judge Peter Moulton, who is also going to likely be part of the 5 that decide decisions somewhere down the line. And he denied all of Donald Trump's requested relief, except for one. So the reporting, hopefully, especially here on this hot take, is that Donald Trump lost. He was unable to stop the trial, day 6 or 7 of the trial, that's already been in progress this week. And he instead said the trial continues. They've taken a time off for the holiday. They'll pick up again on Tuesday. Trial continues with the case in chief in the hands of the New York Attorney General. At least for the next month or two, it'll just be witnesses that she calls. As to the issue about the dissolution of the LLCs, the limited liability companies, and the corporations, the one judge said, for now, I'm going to grant that stay, but for that issue only. The rest of Judge Engoron's ruling has been, in effect, sustained on appeal. The trial goes forward. There was no error, at least observed by this one justice, in the way the summary judgment was handled, the way subsequent rulings were made by the judge, and everything else about his order, including the order requiring Donald Trump to reveal the existence of any new company or corporation or limited liability company where he may be moving assets to, stays in place. That should be the takeaway on this hot take. Trump loses on the motion to stay. Trump loses on getting out from under a requirement, a court order to reveal asset movement, new companies and corporations wherever they're revealed, and have the monitor, who's already in place from last year, keep an eye on everything. The only thing that was granted was the thing that the New York Attorney General did not have a problem with. And probably in the oral argument today down at the courthouse on Madison Avenue, told the judge, Judge Moulton, because she said it in the media, so I'm sure she said it in the courtroom. She said in the media at the trial today that they would not seek to dissolve the companies at the present time. Why? Because it's not in the New York Attorney General's best interest. She's trying to collect $500 million from Donald Trump. She needs those companies to operate uninterrupted and unimpeded. And so she's fine. We don't need to dissolve anything. She's going for the kill. Get the $500 million or more now, then have the entities dissolve. And she's patient. She's willing to wait. I'm sure she said something similar to that to Judge Moulton, and he ruled just that. Okay, you don't have an objection on the Attorney General side. I'm going to stay that portion of the order, and the only portion that goes to the dissolution of the companies, we'll leave that issue for another day for a broader 5-person appellate panel, which Judge Moulton will be a part of. Now, something like this just happened 8 days ago. Very similar. Donald Trump, before the summary judgment ruling came out, tried to get the appellate court to stay the case. It was about, 8 or 10 days away from trial. Now it's started. They try to get the appellate court to say, stop, pull the emergency brake, pull the brake on the train. We don't want to go to trial. The judge is about to make an error. The judge may make an error. We don't like where the judge's head is at. The judge is not being deliberative enough. Take more time to review our papers. Give him 3 weeks, even though he didn't say he needed 3 weeks. I mean, there is no judge who's more prepared than Arthur Engoron to rule on the summary judgment papers in the whole courthouse. I've been involved with cases in front of other judges in this department that have much, much less of a record in front of them. He's been presiding over this case for over a year. He's already heard all the deposition testimony, all the video testimony. He's seen the major documents. There's been hundreds of motions and papers filed in this case. He's heard testimony and has had evidentiary hearings. He's sanctioned and punished Donald Trump time and time again. He knows this case like the back of his hand. So he ruled. It didn't take him long to rule in favor of the Attorney General and rule on her first count that there was persistent fraud and send the rest of the case over to a trial that he's presiding over as the trial judge. And so the appellate court, after Judge Engoron ruled on the summary judgment, 2 days later said, denied, we're not staying anything. Now, at first, one judge or one justice of the appellate division, Justice Friedman, did stay the case for a few days. We reported on it here on the MeidasTouch network. But it was only like for 72 hours until he joined 4 other justices and they decided, no stay. And they lifted it. So just because one judge like today granted Donald Trump one small aspect of what he was asking for, it's temporary. It doesn't mean it's going to be permanent. It just means for now, they'll hold the ring until there's a full panel, and then we'll get to that full panel part. But of course, Donald Trump's lawyers start crowing about this very small Pyrrhic victory. Chris Keiss, Trump's lawyer, said in a statement, "We are very pleased the First Department upheld New York law and put a halt to any cancellation of business certificates, receivers, or dissolution. The trial court's attempt to reach issues, entities, and assets beyond the scope of this case has been suspended." And then, of course, Letitia James, Office of Attorney General, fired back because you think Donald Trump has a media machine? Letitia James doesn't let any stone remain unturned. Donald Trump says something, she takes a press conference, one right after the other. She gets the last word in as the person who's prosecuting the case. She said in her statement, unsurprisingly, Donald Trump is twisting this ruling and falsely claiming victory for a resolution that we proposed. In other words, how do you get a victory? I, as the Attorney General, proposed to the judge, the appellate judge, that a way to resolve this is let the case go forward, of course, and we'll hold in abeyance our efforts to dissolve the companies. And that's all that you got. You got the thing that I gave you. And therefore, you can't claim victory because I already saw the writing on the wall. What she's not saying, reading between the lines to Mr. Keiss, is stay operating. Stay viable as a company, all you little Trump organizations, because you're going to be generating the money that I'm going to be taking off of you when I win the rest of this case. And even on the first claim that I've already won for hundreds of millions of dollars. Stay in business. Stay thirsty, as one of those ads used to say. And so she didn't care. But of course, they're crowing. They got something. Give me a crumb that I can do a press conference with, something that I can mislead my followers with. And they got it. But that's now, you've got the facts. You've got not smoke or sunshine right here on the MeidasTouch network. You've got what happened. What happened is they went down to a hearing. The New York Attorney General conceded that she was okay with not dissolving the companies at the present time, argued against the stay and everything else that they were seeking on the Trump side, and she won. She didn't lose, she won. And just because the one justice signed an order, which we just put up there, doesn't mean that Donald Trump's going to win on that issue at any other future time. It's just a current stay based on the Office of Attorney General agreeing to it. We'll see what the full merits panel of 5 justices, First Department, Appellate Division, do in the future when they have a full briefing, not on an emergency application. In the meantime, the case without Donald Trump goes forward. You're watching the slow, methodical presentation of evidence and witnesses like a cobra squeezing its prey to death. That's why Donald Trump got fed up after 2.5 days, said, I've had enough of this. And as Letitia James declared, the Donald Trump show is over. It's a circus that has left town. And now let's get back to evidence and witnesses, including her courageous move today to call in her case an adverse witness, a hostile witness, a witness for Donald Trump, one of the 2 money men, bag men for Donald Trump in the organization for 40 years, to be her witness today on the stand, and that was Jeff McConney. We cover this kind of stuff just like this at the intersection of law, politics, and justice on the MeidasTouch network. If you like hot takes like this one, you're going to love the MeidasTouch Legal AF podcast. It's what you think. Every Wednesdays and Saturdays only on this network. Follow me on all things social media at MS Popok. Give me a thumbs up for my ratings. And until my next hot take and my next Legal AF, this is Michael Popok reporting.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.